Thank you for joining us for this quarter's Compliance Bootcamp webinar, TrumpEffect. Do I have to comply with the ACA in 2017? Please note the presentation slides will be emailed to all participants by tomorrow. At the bottom of your screen, you'll see several widgets for you to use during the presentation. For example, if you have a question, please click the purple Q&A icon to the left. At the end of the session, the yellow certification icon on the right will become active for you to download your SHRM and HRCI credits. Speaking today is Dan Cooperstein, Senior Vice President of Compliance at Corporate Synergies. Corporate Synergies is a national insurance and employee benefits brokerage and consultancy where Dan is a respected thought leader on healthcare reform. He has published many articles and videos on the Affordable Care Act and other laws and regulations, which can be found in the Knowledge Center at corpsyn.com. Dan is an ERISA attorney with experience in a broad array of sophisticated employee benefits and labor and employment matters, including the ACA, COBRA, HIPAA, and GINA compliance. At this time, I will turn it over to Dan.
Thanks, Ashley, and welcome to today's webinar on the Trump effect on the Affordable Care Act. As I'm sure most of you are aware, President Trump and the Republicans in Congress have declared the end of the ACA, but they're still trying to sort out the details on an ACA replacement plan. News about the ACA's repeal and replace effort, including other related developments like the President's executive order on the ACA, have caused employers a lot of concerns, a lot of questions about what's next for the ACA, and so that's going to be the focus of our presentation today. What's next? And we're going to take a look first at President Trump's impact, and through the lens of recent developments, we're going to look at the new executive order, and we're also going to look at the agency appointments, and then we're going to look at some of the other plans and proposals that are out there, including the Tom Price plan. Then we're going to look at what we call the Walking Dead, sort of a look at where what's probably still happening, what's probably not going to be happening for the ACA, in the months and years to come. And then we're going to take a look at the 21st Century Cures Act, which was a law signed at the end of 2016 that we think is probably a sign of what's to come, and a new focus on consumer-driven health care under President Trump and the Republican majority Congress. And then we're going to take a look in part two of our presentation at the ACA as it currently stands, just looking at what we still have to comply with in 2017. And then part three, we're going to do a brief refresher on the pay or play or employer mandate requirements, as well as the ACA's information reporting requirements. And then in part four, we're going to look at how pay or play is different this year as opposed to earlier years. In part five, we're going to look at how ACA information reporting was different when you're reporting in early 2017 based on the 2016 calendar year. And then finally, we're going to wrap up with a discussion of recent developments, which are changing pretty much every day. So even as we rolled this out, literally about an hour to an hour and a half ago, changes have already happened. So we're going to try to give you as many updates as we can. Okay. So let's talk about the Trump effect, its impact on the ACA and U.S. healthcare policy. And just for starters, before we get started in today's webinar, we did have two quick disclaimers we want to say. First of all, number one, we do not take any political positions here at Corporate Synergies. We're just reporting on compliance-related developments that can have an impact on you and as an employer and sponsor of a health and welfare plan. And we're really just trying to cut through all the chatter that's out there and in the media and make these developments easier for you to understand so you can get into compliance. The second disclaimer we have is that we'll be referring to President Trump's proposed healthcare policies that he disclosed on his campaign website and transition website and other disclosures as Trumpcare, but that is not intended to be disrespectful or derogatory in any way, and it's just an easier way to refer to President Trump's healthcare policies in their entirety. And also, we don't think that he'll be too offended about this, given his propensity to enjoy putting his name on things. So we think he'll be okay with it. And finally, we have a lot of people on today's call today, so I just wanted to add that if you send in a question, we are going to try our very best to get to it as soon as possible, definitely today, but we may not get to it right away just because there's so many on the call. So let's go ahead and get started. And we're going to start off, first of all, with our first section here about what's next for the ACA. And we're going to talk about some recent developments first. First of all, on December 13th of 2016, the President Obama, our last president, signed into law the 21st Century Cures Act, and we're going to talk a lot more in detail about that later and how that may be a sign of what's to come with the repeal and replacement effort. And then there were two big developments that happened very recently. The Senate and House approved a budget measure that on January 12th and 13th that was designed to allow Republicans on Capitol Hill to use a process known as budget reconciliation to roll back major parts of the ACA. And the benefit to Republicans of budget reconciliation is that it means that a law designed to repeal and replace the ACA can pass with only a simple majority of votes, which means they can get through without a filibuster by Democrats. So the burden, however, that's a good thing for Republicans, and the burden or downside for Republicans of budget reconciliation is that laws that are passed through budget reconciliation cannot effectuate the non-budget related parts of a healthcare policy. So any such law would be limited to budgetary or fiscal provisions like taxes and fees and things like that. In any event, it is a big development with respect to the repeal and replacement effort. So the next question, of course, is what about timing? Well, the budget resolution did call for them to have a draft proposal by the end of January, which, to the best of our knowledge, has not been released yet. But there are some different comments out there by top Republican leaders about when this is all going to happen. Some top Republican leaders out there are saying they plan to move to repeal and replace the ACA along the same track. That is, they expect repeal and replace to happen at the same time. Other Republican lawmakers have been out there saying that while repeal could happen in the first 100 days of the Trump presidency, the replacement process and the replacement legislation could take as long as 2 to 4 years before it becomes effective. So, that could still be a long ways away, and we're watching it every step of the way. One thing is still very clear, and that is that Republican lawmakers are struggling at this time to still come up with details on how it's going to work. And as recently as this past weekend in Philadelphia, they've been regularly meeting to discuss how it's going to work. The bottom line is that it's unlikely that we'll see major changes to the ACA's rules for 2017, but after 2017, it's not so clear. We'll keep monitoring any replacement plans very closely, and we're going to talk today about some of the more popular replacement plans that have been proposed. So that's what's been happening. The other, of course, big thing, which I'm sure all of you saw in the news, was that President Trump signed an executive order weakening the ACA on January 20th. So literally within hours of becoming president, President Trump signed an executive order, and we'll talk more details about that in a little bit. But first, we wanted to start with the agency appointments over the folks who were appointed by President Trump to lead the agencies that are responsible for implementing the ACA and U.S. healthcare policies, because these are the people who are going to be most directly involved in the years to come with shaping our healthcare policy in the years ahead. The first, of course, and the one I think that got the most maybe popularity or fanfare and news coverage was Tom Price. Tom Price is the six-term Georgia representative. He's a 62-year-old orthopedic surgeon he serves now as chairman of the House Budget Committee. He's been a leading critic of the ACA. He's offered several detailed plans to repeal and replace the health care law. He was among the first Republicans to introduce an alternative to the ACA when Democrats were debating the health care reform in 2009 and 2010. He's also closely connected to the House and with Paul Ryan, and he's expected to be a key player in helping to pass the replacement plan. He's also very close with Vice President-elect Mike Pence, and both are former chairs of the conservative House Republican Study Committee. Now, this says pending Senate confirmation, but literally about an hour and a half ago, he was confirmed. So obviously we'll be watching everything he says very closely and keeping you updated, both on our website and through alerts of all kinds. Let's talk about the other agency appointments that will have an impact on healthcare in the years to come. One of the big ones, of course, is the Secretary of Labor. Now, while ERISA and health benefits are typically really kind of managed by the head of the EBSA division of the Department of Labor, Employee Benefit Security Administration, still the Secretary of Labor still has a pretty big role in healthcare, driving healthcare policy. President Trump has selected Andrew Puzder, who is the CEO of CKE Restaurants, which is the parent company of Hardee's, Carl's Jr., and he began his career as a lawyer. He helped the founder of Carl's Jr. avoid bankruptcy. He eventually relocated to California and became the general counsel for CKE and later CEO. He's a strong advocate for deregulating government involvement in business. He's opposed minimum wage increases and has said that government benefits discourage workers from seeking higher paying jobs. So I think what we'll see from him is just an effort to reduce regulation and sort of red tape that binds businesses, and it should be a good thing for employers, but we'll see how that plays out. He has not been confirmed yet. The other one that is really important for healthcare is the Secretary of the Treasury. As an agency, is one of the big things about healthcare, of course, is the tax implications. Whenever you're considering a new plan for your workforce, you always have to look at the tax implications, and I think one of the big agencies that's been involved in regulating the ACA has been the IRS and Treasury. So President Trump has selected Steve Mnuchin, who was Trump's campaign finance chairman. He worked at Goldman Sachs for 17 years. He was a partner at Goldman Sachs, and after leaving there, created his own hedge fund, and then subsequently became the head of a California bank called One West. He does not have government experience, but he's already proposed several different things that he thinks would make it a more employer-friendly climate for business in this country. And then, of course, we have Seema Verma, who has been selected to head the Centers for Medicare and Medicaid Services. Ms. Verma worked closely with President-elect Mike Pence, helping to design the Medicaid expansion in the state of Indiana. And her consulting firm has helped other Republican governors implement similar plans. So she's a very good, very deep understanding of how Medicare and Medicaid work. And she is expected to have a major role in the block grant Medicaid program that's expected to be rolled out by Congress. So let's talk now. Those are the big agency appointments that we're watching very closely. And we should just mention that Price and Mnuchin were both confirmed. That those slides did not reflect that, since that just happened about an hour and a half ago. So when we send out a copy of the presentation, we will update that, indicating that they were confirmed. But let's talk about the executive order, because I think this is definitely in the last, since January 20th, we've gotten so many questions about this from employers across the country. Just really concerned. Of course, the first question we get is, well, does this mean we still have to comply with ACA information reporting? And the answer is yes. You do have to comply still with the ACA information reporting requirements. But let's go through the executive order piece by piece, and then we can talk later. We'll talk afterwards about its impact. The first part of the executive, there's really 5 main parts to the executive order. The first part is just the mission statement. It explains that we intend to promptly repeal the ACA and reduce its costs and penalties. The second part says that agencies can use their discretion to grant waivers, exemptions, and delays to reduce costs. And when it refers to costs, it refers to fiscal costs on states, as well as fees, taxes, penalties, and burdens on individuals, families, healthcare providers, and other entities. Now, it does not mention employers. It does not expressly refer to the employer mandate or ACA information reporting. It just says individuals, families, healthcare providers, and lists some other different entities. but it is an interesting provision, particularly in light of Section 5, and we'll get there. Section 3 says agencies can use their discretion to give flexibility to states when implementing healthcare programs. Section 4 says agencies must encourage a free and open market in interstate commerce for health insurance. And 3 and 4 are pretty consistent with everything that Trump has been saying on the campaign trail and on his website. 5 is really interesting. It says that agencies must comply with the Administrative Procedure Act and other laws when carrying out the directives of this order. And that's a reference really to the comment period for regulations. And what it essentially means is that the agencies still have to comply with laws that have been finalized, that have been commented upon and finalized by the public. So it clearly states that the agencies cannot just make up new rules that contradict laws and rules that have been finalized. And for that reason, it's unlikely that there is much that the agencies can really do to waive fines, penalties, and things like the employer mandate or ACA information reporting without first having to nullify or repeal those laws and regulations that have come before. So in many ways, the end result is that the executive order really functions in many ways as a statement of intent or a mission statement for the new administration, indicating their intent to repeal the ACA, but it doesn't have much legal power. Now, it does, it is consistent with a more recent executive order, which would indicate that he plans on really freezing a lot of this regulatory activity or reducing it. In fact, Trump recently said he's going to cut regulations by 75%. Now, we don't know exactly what that means as far as how they're going to go about it expressly, or what the specific way they're going to take, or the specific path they're going to take to get there. But it does indicate a sort of freezing of this, constant regulation output that we saw in the prior administration. Okay, so let's talk a little bit about Tom Price plan. And the plan is called, the bill that he proposed was called HR 2300, the Empowering Patients First Act. The plan has similarities to both the Better Way plan put forward in 2016 by House Speaker Paul Ryan and the plan that Trump outlined on his campaign website and transition website. So but it's probably the most favored by Republicans as a replacement roadmap because while it includes traditional GOP ideas such as health savings accounts, high-risk insurance pools, and allowing interstate insurance sales, and so it's similar to other plans out there, it's also the most detailed. I think that's really the key thing here. It's already been put into legislative language, so that gives it a definite advantage over other plans, and it's something that that the Republicans really can kind of grasp onto and use as a model or template. So let's take a look at some of the major provisions here. We've highlighted some of the key provisions of the Tom Price plan. I think one of the most interesting is this idea of a universal tax credit, which provides for refundable age-adjusted tax credits for the purchase of qualified health insurance with amounts tied to the average insurance on an individual market, adjusted for inflation. So the way it's set up is that there's these tax credits that people can get to purchase health insurance, but they're static. They're based on age only. So that's really a big contrast to what we have now under the ACA, where premium tax credits are available for individuals to purchase health insurance on the exchanges, but the amounts of those premium tax credits are based on annual household income, whereas in contrast, this proposal would just give certain set amounts. So if you're a child up to age 18, you could get $900. If you're between the ages of 18 and 35, you get $1,200. So it's a very static kind of proposal. Now, the credit would be available to those who purchase qualified health insurance through the individual market. And we should just define qualified health insurance just briefly. It cannot include things like standalone vision, standalone dental, those types of accepted benefits. It has to be, like a major medical plan. It has to have some real substance to it. So there are some restrictions and limitations, and it would allow individuals who are enrolled in employer-subsidized group health plans to opt out of employer plans and receive the credit instead. And there are some interesting other provisions. Section 131 of the bill provided a limitation or cap on the employer-provided health coverage deduction amount. So it would allow for the employer exclusion of health care coverage to be up to $20,000 for a family and $8,000 for an individual, with any additional funds used to be taxable dollars to the employer. So this is one, I think, the most controversial for employers, and a lot of employers have already expressed their dislike of this provision, saying that this is too low of a cap. The cap has to be raised because anytime you cap the employer tax deduction on health care, it's going to result in employers just offering less health care. So that's probably one of the more controversial provisions. There are some other interesting provisions here. There's a provision in Section 135 saying that employers can institute automatic enrollment for health insurance for those plans that meet a federal nexus test, so the larger plans out there. And the states cannot prevent this, so the states cannot put rules out there that would block the auto-enrollment provision. There's also a credit for small employers that adopt either automatic enrollment or a defined contribution plan. And the defined contribution option in this law is kind of like what we've seen a little bit already, even under the ACA. You know, if a small business, let's say, gives a certain amount of money, a defined contribution amount that the employees can use on the individual market or with certain providers, this law would give you an incentive for that. Specifically, it would say that small businesses with 50 employees and under can receive these grants of up to $1,500 to offset the administrative burden to institute automatic enrollment or a defined contribution. And the credit would be available on a one-time basis, but the ability to claim a credit would expire 2 years after enactment. There's also an interesting provision here about reporting. Under Section 601 of the bill, it would require insurers to report claim information under certain group health plans, and if they didn't do it, there would be certain penalties. The reporting has to occur within 30 days after the date a health insurance issuer receives a request for a report of claim information from a plan sponsor or plan administrator, and then the health insurance issuer has to then provide the requesting party with the copy of the report. And the health insurance issuer is not required to provide a report more than twice in any 12-month period, and the employer must have 50 or more employees. So there are some restrictions, limitations, but very interesting proposal by Mr. Price. And then, of course, we have the Paul Ryan plan, which is extremely popular among Republicans. It's called A Better Way. It came out in June 2016. Some of the major provisions, I just remember this was not drafted like a legislation. The way it's come out in more like an article or a bullet point kind of thing. So it doesn't give as much specific detail, but you'll see a lot of the same themes that you saw in the Price plan. He wants the following provisions to increase choice and lower costs. He wants a refundable tax credit that's portable. So people who without access to employer coverage, Medicare or Medicaid, they'll be offered a refundable tax credit to buy health insurance in the individual market, and that will be portable from job to job, and it can be used in retirement years. And like the Price proposal, the credit would be age adjusted, and unlike the ACA, it would be static. It is not, and like the Price proposal, that amount of the refundable tax credit would not change with income. So, it would not change. He would also expand patient-centered healthcare through HSAs, make it easier to use HSAs and transfer funds to and from HSAs. And then he would eliminate the Cadillac tax to help preserve employer-sponsored health insurance. His view is you can replace the Cadillac tax, which he calls an unfair tax on workers, with a cap on the employer tax deduction for health insurance. He states that will lower premiums in employer-sponsored plans, and I think it's kind of substituting one bad thing for another bad thing. I think by some employers look at that, because on the one hand, while pretty much everyone that's an employer sponsoring health insurance hates the Cadillac tax, now as a replacement of that, and I believe it was like an $84 billion revenue shortfall that results from taking the Cadillac tax out of the picture. But the replacement of adding a cap to the employer tax deduction would still generate a lot of revenue. So that's kind of how they're looking at that. They also would make it easier under this plan for individuals to purchase plans across state lines, so with the goal of making insurance more competitive and allow people to shop more broadly for more affordable policies and prices. And there are some provisions in the Ryan plan designed to protect patients, including the pre-existing condition rule. So it would prevent insurers from denying coverage due to a pre-existing condition. They would protect coverage for young people by allowing dependents up to age 26 to stay on their parents' plan. It would also prohibit sudden cancellations. So it would prohibit insurers from turning away patients when they renew for being sick. It would also give states more discretion and authority over Medicaid programs. And we've seen a lot of talk about this, both by Paul Ryan and others, about this block grant Medicaid program where they would give a certain amount of Medicaid funds to each state, and then they would give greater discretion to the states as to how those Medicaid funds would be allocated. And interestingly, this could allow states to say, well, here are the requirements for getting the Medicaid funds. If you're a criminal or drug addict, or you have a criminal record, whatever it is, they could limit the amount of Medicaid funds that the person gets. So it's very interesting. We'll see how that plays out. Still a lot of details yet to be figured out with that. Enforcement of the Hyde Amendment. So the Paul Ryan plan would prevent federal taxpayer dollars from being used for any kind of abortion or abortion services. So that's a big kind of overview of some of the key provisions of the Paul Ryan plan. And I think one question that we still continue to get since President Trump was elected is, well, what's in Trumpcare, right? What's in this? What are the policies that President Trump really likes? And I think when you look at his proposals that he put on his campaign website and that he put on his transition website that he's been talking about, kind of see a little bit of everybody in there. He kind of likes a little bit of each. Even Tom Price, who's not pictured, but he likes the Tom Price proposals. He likes Paul Ryan's. Even some of the things that we saw in Romneycare and in Obamacare or the ACA. So you'll see a little bit of everything in Trump's proposals. So here are Trump's major policy proposals, which we just took from his campaign website and his transition website and things he'd said on the campaign trail. But basically, he said he's going to repeal and replace the ACA, but he likes certain parts of it. He likes the pre-existing condition rule. He likes the age 26 dependent coverage rule, and those are in the ACA. It's unlikely those will be changed. He wants it to be easier to sell insurance across state lines, like the Paul Ryan plan. Interestingly, there is something in the ACA already that covers this called Section 1333 of the ACA, which permits states to enter into what are called compacts or agreements under which plans can be sold in all of the participating states, but currently only 5 states participate. And another problem with the ACA now is that the small group rules, the ACA's small group rules have really made it hard for employers to purchase affordable coverage in some states. So any laws that are going to be designed to make that easier, I think, will be a big relief for smaller employers. He also wants tax deductions for individual premium payments, so to allow individuals to fully deduct their health insurance premium payments. And he wants it to be easier access and flexibility for HSAs. So he wants them to become part of the estate of the account holder, and it'd be easier for you to transfer those HSA funds to other family members. HSAs are right now incredibly popular, so that will significantly increase the popularity of HSAs. His other policies include greater provider price transparency. There really isn't anything like that in the ACA, so that would be an interesting addition. It would require providers to give more information about their prices to help individuals to shop around for cost-effective care. The block grant Medicaid to the states, that's consistent with what Paul Ryan said. He wants it to be more authority and discretion on the part of the states, so there's less of this, less incentives for fraud, waste, and abuse. He also wants to increase competition among drug providers and open the drug market to foreign competition in order to lower costs. And then he wants the Cadillac tax to be repealed, and that probably will happen, given that has such bipartisan support. And we did before we did want to kind of look at that in the context of what do we still have to comply with in 2017 for the ACA. And the answer is, of course, an obvious yes. You still have to comply. but there are some things that look like they're still alive, but maybe will be dead soon. So we've this first slide kind of has things that we think are probably dead, like, probably a zombie or, probably on their way out very soon. And the second slide has the things that are, I would say, more possibly dead. So the first is very likely dead. The second slide is possibly dead. And we start that with the Cadillac tax, that 40% excise tax on high cost and health insurance, slated to go into effect in 2020, very likely dead. Then also the non-discrimination requirements for fully insured health plans. These were rules that were designed, rules in the ACA that were supposed to prohibit sponsors of fully insured health plans from discriminating in favor of highly compensated employees. Those rules were never drafted, and given the, everything that's been happening so far, it seems extremely unlikely that Treasury will draft those or finish that project. There were also proposed opt-out arrangement rules that came out. Really, they were introduced at the end of 2015 in guidance and were proposed in 2016, never finalized. In fact, they were delayed in late December of 2016. So probably not going to happen. Very, very likely to be dead. And then, of course, we saw these proposed. This is not technically an ACA provision, but it's related to the ACA. There were proposed rules that came out in 2016 that were designed to require additional disclosure information on the ERISA Form 5500 requirement, and also to include more ACA-related information, and also to eliminate the small employer exemption from the Form 5500 requirements. And that's probably going to be out. I mean, I don't see why there would be any reason to make that so much harder on small businesses by, it doesn't seem like that's likely to happen. And also, if these last two things had been proposed but not finalized, so it's just unlikely that those things will be finalized under the Trump administration. And we look at now in the second slide the ones I think probably we get more questions about, but I think are still more of a question mark at this point, and it's unclear kind of what's going to happen here, but they are very unpopular. So I think that the two at the top of our list are the employer mandate and the individual mandate. The employer mandate is the tax on employers for not offering affordable, adequate coverage to full-time employees. We'll talk more about those details shortly. And the individual mandate is the tax on individuals who are not enrolled in coverage under the ACA. And while these are extremely unpopular, they are taxes that really fund the ACA's popular parts, including, the pre-existing condition rules and other things that people like about the ACA. So eliminating them would be, would lead to a big shortfall in revenue for the country. But those, also they would eliminate the ACA information reporting requirements, because if you eliminate those mandates, there would be no need to then report on what you did or did not do. So that's, I think, the big question mark that we still have out there. Now, if you read the language of the executive order, there was some language in there that suggests that they want to get rid of the individual mandate as soon as possible. You could have read it that way, but it's not entirely clear yet that that's what's going to happen. We're still watching and watching that very closely. Also, one provision is the availability of the premium subsidies on the exchanges, and given that a lot of these proposals that are out there have offered these static refundable tax credits, that's probably what's going to be replacing the current ACA model of premium subsidies. But it's not clear what that's going to do. Is that going to mean that people are going to drop out of the exchanges or high-risk pools, as they may call them under the Republican plan? It's not clear then, of course, what that effect would be if a lot of healthy people leave the exchanges. Then the insurers might also leave, and that may lead to a death spiral. It's not clear, what's going to happen for those who really need the exchanges. One thing is that Trump has said that there will be affordable health coverage for everybody. And he's also said when he's on the campaign trail, he didn't want to see people dying in the streets. So there probably will be some kind of thing, even if it's not called the exchanges and it's not called premium subsidies, there's going to be something kind of like that in some form or another under the Republican proposal. It may just be called a high-risk pool with refundable tax credits, but we'll see how that works out. Of course, extremely unpopular are the other ACA taxes, including the medical device tax and the increased Medicare taxes on high earners. Extremely unpopular, but we have yet to see any clear way that they're going to get rid of those as of yet. Okay, so that's the kind of big picture of what's going on with Trumpcare and the repeal and replace effort. Now, we did see this law come out at the end of 2016 called the 21st Century Cures Act. Very, very interesting law signed by President Obama, but there's a lot of bipartisan support for this. A lot of the fanfare that came out about it was that, look, it's going to lead to a lot more funding of the opioid epidemic problem. It's going to create greater funding for cancer research. But there were interesting provisions in there that relate to health insurance compliance and really a big focus on consumer-driven healthcare, which leads me to plug a future webinar that we're going to be doing. We're going to explore consumer-driven healthcare in one of our upcoming webinars this year because we think it's really going to have a big impact on. We think that the Republican replacement plan and Republican healthcare policies will really be focused on consumer-driven healthcare, just based on everything we've seen thus far. And this is a great example of that. The first big change that it makes to the ACA is that it resurrects standalone HRAs, which I think everybody had thought were dead for years. And these standalone HRAs are called Qualified Small Employer Health Reimbursement Arrangements. They not only do they allow these CUSERAs to be standalone HRAs, but they're also allowed to reimburse individual premiums, which was not allowed under the ACA. And that's typically what would happen. If you remember, before the ACA, small employers often did this. If they had like two workers, Joe and Jill, they would then, and they didn't have enough money to have a group health plan, they would just say, hey, look, just go out in the individual market. We'll reimburse you for the cost of your premiums. Those types of HRAs were prohibited under the ACA, but now they're allowed again under this new rule for CUSERAs. There are some requirements. The employer cannot be an applicable large employer, so it has to have less than 50 or more full-time employees and full-time equivalents. The employer cannot offer a group health plan to any of its employees. Additionally, the arrangement cannot reimburse in excess of $4,950 for individuals or $10,000 for family coverage. It can only reimburse code Section 213D medical expenses. There's also an annual notice requirement so under this notice requirement, you are required to provide notice to all eligible employees at least 90 days before the beginning of each year, or if later before an individual is first eligible to participate in the CUSERA. And the notice has to describe the amount of reimbursement available under the CUSERA and explain that the employee must disclose the presence of the CUSERA when applying for or renewing coverage purchased through the exchanges. The penalty for failing to provide the notice is $50 per employee, up to a maximum of $2,500 a year. So the notice requirement is important. And there's also special ACA premium tax credit coordination rules that apply. Very interesting development, and we think it really is a sign of what's to come with the repeal and replace efforts that are out there. Now, we did see, in addition, there were some other compliance requirements that came out of this. One is the requirement for increased enforcement of the Mental Health Parity and Addiction Equity Act rules, or MAPIA. I've heard that pronounced in many different ways, but I'll say MAPIA. And MAPIA is a law that basically says, look, if you're going to have mental health coverage, you have to treat it the same as other types of health insurance coverage, and so provides for it has to be treated the same. So, for example, if you're going to have a certain amount of coverage for certain physical health things, you have to have the same options for mental health, generally speaking. Now, the new law provides for increased audits to ensure that insurers and group health plans are complying with the mental health parity laws, and says that the appropriate agency is required to audit the plan if it's determined that the plan has violated the mental health parity rules at least 5 times. And in addition, it requires coverage offered for eating disorder treatment to be provided in a manner that's consistent with the mental health parity rules. So if you have, let's just say, substance abuse disorder treatment offered by your plan at X amount of dollars, then it has to be the same amount for the eating disorder treatment. You can't say, well, you only get $5 for eating disorder, but you get $10 for substance abuse disorder treatment. So, interesting rule. In addition, there were changes to HIPAA that required the Department of Health and Human Services to ensure the availability of resources regarding the appropriate use and disclosure of PHI. and required HHS to release guidance on permitted uses and disclosures of PHI, to clarify confusion about how these HIPAA rules will work with regard to mental health treatment and other patient care circumstances. So they just want a lot more clarity about how HIPAA and PHI work in the mental health context. So let's take a quick big picture look at the ACA and kind of where it stands now, what we still have to comply with. We had a really busy 2016. A lot of things happened in 2015, 2016. In 2017, as we look forward, there is going to be this new SBC format that's going to be required beginning on April 1st of 2017. So for plan years that begin on or after that date, you'll have to use the new SBC format, which kind of has the summary benefits of coverage, and it has a new format that's more accessible, easier to use. It has hyperlinks and new examples. Also, we saw that on January 1st, 2017, the grandfather plan rules went into effect. We refer to them generally as the grandfather plan rules, but it's sort of a compendium of a lot of different rules regarding rescission of coverage, out-of-network coverage, a lot of other rules that came out as guidance in earlier years, and that were sort of collected in this set of rules. And then we also we're expecting the final opt-out rules to go into effect, but it looks like it's probably not going to happen, so that's why we added the question mark. And then in 2019, the new Form 5500 reporting rules were slated to go into effect. Probably not going to happen. Probably should have added another question mark there as well. Unlikely to happen. 2020 is when the Cadillac tax is slated to go into effect, and again, very unlikely to happen. And then you'll see a green arrow, non-discrimination testing for fully insured plans. It's very unlikely that that's going to happen either. So again, more question marks, but those are the things that we don't think are probably going to be still on the roadmap, and still, still out there, but probably not going to happen. And we do want to mention some of the problems that were happening with the ACA. Regardless of which candidate was to win the election, there's going to have to be some changes to the ACA because the current structure of the exchanges are really unsustainable. When you look at the premium changes for the ACA marketplace plans between 2016 and 2017, you see that there was a 145% increase in Phoenix, Arizona for this average plan premium cost, and really it's just unacceptable. And you saw that the number of exchange enrollees who had a choice of 3 or more insurers went down to 57% from 85%, and you also saw that there was that more than 40% of all healthcare.gov counties had just one insurer, and so we saw this big pull out of insurers from the exchanges. We saw the costs go up, so something has to change with the exchange system. The way it's currently modeled is not going to work, and I think that's the first priority for any ACA replacement plan that's out there. So before we talk about kind of what's going on and what we have to comply with, we wanted just to do a brief refresher on the basic rules of pay or play or the employer mandate, and also the basic rules about ACA information reporting, so we can talk about some of the changes this year. So let's start with pay or play. Pay or play requires an applicable large employer, which is an employer with 50 or more full-time employees, including full-time equivalents, to offer health insurance coverage to at least 95% of the full-time employees and their dependents, which are their children, their dependent children, not spouses. And if at least one of the full-time employees receives a premium, if they don't do this, and if at least one full-time employee receives a premium tax credit to help pay for coverage on an exchange, then the employer will be subject to what's called the large penalty, the large payer pay penalty. But then there's also, even if the employer does offer coverage to at least 95% of its full-time employees and their dependents, but at least one full-time employee receives a premium tax credit on an exchange, either because they were not offered coverage because they were in that 5%, or because the coverage that was offered was not affordable or did not provide minimum value, then the employer is subject to what's called the small penalty, or the B penalty, because it's under 4980HB of the code. And so how do employers avoid this? Well, they have to offer coverage that meets these 3 requirements. If the coverage offered meets these 3 requirements, then the individual will be ineligible for a premium tax credit, which are MEC, minimum value affordability. MEC, or minimum essential coverage, is a very baseline level of coverage. It does not include standalone vision or dental. Minimum value means that the plan's share of the total allowed costs of benefits provided to an employee is at least 60%. And that health plans that exclude substantial coverage for inpatient hospitalization or physician services do not meet the minimum value threshold. And affordability, I think, is the one that out there that really is on those things are, for the most part, provided by the insurance companies, but employers really have to determine if the coverage is affordable for their workforce. Affordability in 2017 means that it's the cost of coverage cannot exceed 9.69% of annual household income, but since employers can't determine their employees' annual household income, employers can use one of three safe harbor tests. The coverage, the W-2 wages test, which says that the cost of the lowest self-only coverage cannot exceed 9.69% of the employee's W-2 income. The rate of pay test, which says that the lowest cost coverage cannot exceed 9.69% of the lowest hourly rate paid by the employer multiplied by 130 hours a month. And the federal poverty line test, which means that the lowest cost self-only coverage cannot exceed 9.69% of the federal poverty line. And we just wanted to kind of go and just take a quick look back at 2015, 16, and 17, and just kind of offer these to you as sort of reference slides to show you kind of how the amounts have gone up over the years. And in this slide, you'll notice a little different because in 2015, you only had to offer coverage to 70% of the full-time employees and their dependents to avoid the large penalty. And that, of course, in 2016 and years after went up to 95% of the full-time employees and their dependents. So you can see how it went up from $2,080, $2,160, $3,240. You can see how it is in each of these years. Now, 2017 is estimated, but we estimate that the large penalty will be $2,260 a year, or $3,390 for the large penalty, or $3,390 a year for the small penalty. So gradually going up over the years. And we just wanted to briefly talk a little bit about some of the basics of ACA information reporting, which is the process used to determine if employers have complied with the employer mandate. And there's two different types of reporting out there. There's what's called MEC reporting under Code Section 6055, which is required by insurers and self-insured plan sponsors. And then there's pay-or-play reporting required under Code Section 6056, which requires all applicable large employers to report on the coverage that was offered to their full-time employees. For MEC reporting, all those who are enrolled in the plan have to be reported on, including non-employee directors, COBRA qualified beneficiaries, retirees. And for pay-or-play reporting, all full-time employees have to be reported on. The forms that are used to report, for MEC reporting, you can use the forms 1094B and 1095B. You can also, if you're an ALE with 50 or more full-time employees and full-time equivalents that is sponsoring a self-insured plan, you can use also the forms 1094C and 1095C for reporting. But if you're, otherwise, if you're just doing pay-or-play reporting, you have to use the C forms, forms 1094C and 1095C. Okay, so now that we've covered the basics of how these things work, let's talk about how year 3 is different for pay-or-play. And the main thing, first we'll go between 2015 and 2016, because I think that was the year that the major changes happened. And you can kind of see that a lot of things happened, right? The penalty amounts went up, like we've just talked about. More employers were subject to penalties in 2016 than 2015. The requirement went up. The covered employer requirement went up from 100 in 2015 to 50 or more in 2016. First-year transition relief was no longer available in 2016. So, for those lucky employers that had a non-calendar year plan, they could start their year, let's say in July. They wouldn't have to comply. If they started the plan year on July 1, the first half of the year they wouldn't have to comply. So that's no longer the case in 2016. There was also the special 6-month determination period for ALE status under the ACA rules that said that you could look back, whenever you're determining if you're an ALE, you look back at the prior calendar year. So this special rule in 2015 said you could look back at the 2014 year and choose any 6-month consecutive period of time to determine, if the number of employees you had, was above or below that 50 number threshold. So that was a kind of nice rule that you had for 2015, but that you don't have for 2016. 2016 was also the first year employers were supposed to receive penalties. It really hasn't been rolled out in any way, but we're expected to see that for 2015. And then, of course, there was an interesting case called Marin v. Dave & Buster's that came out that in 2016, in February, was decided in February 2016. It was a denied, the Southern District of New York District Court denied an employer's motion to dismiss a claim that the employer had violated Section 510 of ERISA by reducing employees' hours in order to avoid ACA penalties. And there the court really focused on the fact that the employer did this to try to get out of the Obamacare ACA penalties and had, said that that's what they were doing. So the real takeaway there is you may be violating ERISA even if you're just trying to get out of the ACA requirements. So you have to be very, very careful. Make sure you have a legitimate business reason for why you're reducing hours. There were also some new rules that came out for cafeteria plans and for payments, in addition to opt-out payments, other types of payments that are made through the cafeteria plan and how those can expose an employer to penalties under the ACA. And also we saw in 2016 employers begin to appeal these exchange notices that came out talking about the fact that employees were qualifying for and receiving coverage on the exchanges. And so we have here a little bit of an overview, some helpful slides that kind of show you what's changed between 2015 and 2016 and what's changed between 2016 and 2017 with regard to the pay or play penalties. In addition, we've attached in the next to this presentation a really helpful chart that kind of shows you how all the dollar amounts went up over the years from all the way up to 2018 that we know. So one area of misunderstanding, I think, and we wanted to do a couple of slides here on this, is just to explain the federal poverty line safe harbor because it caused a lot of confusion. The key thing to understand is that the reason why it caused a lot of confusion is because the IRS calculates eligibility for the premium tax credit based on the prior year's federal poverty line guidelines, but when looking at the safe harbor, they're looking at the current year's federal poverty line guidelines. But the pay or play rules allow you as an employer to use the guidelines that are in effect within 6 months prior to the first day of the plan year. So it's an important rule to remember when you're planning ahead and you don't have the federal poverty line guidelines yet for the year. What that means for 2017 is that if your plan year was starting on January 1 of 2017 and you didn't have we don't have the 2017 federal poverty guidelines, you can use the 2016 number of $11,880 to come up with your calculation. And you can see here at the bottom of the slide 48 how you could plan for 2017 federal poverty line. If the coverage does not exceed $95.93 a month, you should be okay. Okay. Here are just some helpful slides showing if coverage was affordable in 2016 versus if coverage was affordable in 2017. All that really went up is we saw the number, the 9.66% threshold go up to the 9.69% threshold. So that was the big difference between 2016 and 2017. So let's talk a little bit about how information reporting was different. And I think there we saw, we saw a lot of the same things that we saw with the pay or play rules, right? We lost that transition relief, and that transition relief made it easier to comply in 2015 with ACA information reporting because you didn't have to, worry about those earlier years to, for if you had a non-calendar year plan, and those transition rules are not effective for 2016. You also you had extended times to both furnish and file in 2015 when you're reporting on the 2015 year and early 2016. But now you're not going to have those. You're not going to have the extended time period to file, but you will have an extension to furnish, which was released at the end of last year in IRS Notice 2016-4, and we'll go over what those new deadlines are in just a little bit. Also, the penalty amounts went up from $250 per return to $260 per return, and from $3 million as the maximum annual penalty to $3,193,000. There were also new codes for conditional offers of coverage to an employee's spouse that had to be reported on line 14 of the Form 1095-C, and those codes were 1J and 1K. And there was a new required plan start month field that was on the old form, but now it will be mandatory for 2016 when you're reporting on that year in early 2017. There's some other interesting changes that happened as well. We're not going to go into a lot of detail on these things. There's some clarifications about how COBRA should be reported, aggregated ALE groups, as well as the fact that you can't, when you're doing the substitute Form 1095-C, they have to be furnished to employees. They can be printed in portrait, but the files have to be filed in landscape, so there's some printing requirements. There were also some interesting rules that were proposed in August of 2016 that talk about the TIN solicitation process that says employers must attempt to correct errors in TINs in order to qualify for penalty relief, and it gives you some special time periods that you need to use. And if reasonable efforts are made and you can't get the TIN, you can still use the birth date. There's also an important clarification about HRAs, indicating that if the employer sponsors other Met coverage, then they don't have to worry about reporting on behalf of the HRA. So very helpful rules released there. And here are the deadlines. This is a very helpful slide that kind of shows you what the new deadlines are. Note that in 2016, when you're reporting on the 2016 calendar year, we got this extension to furnish those Forms 1095-C from the normal deadline of January 31st to March 2nd of 2017. But the filing deadline has not changed, and if you're filing, if you have less than 250 returns, the filing deadline is February 28th of 2017. If you have 250 or more returns, the filing deadline is March 31st of 2017. So filing deadline stayed the same. Now, there were a lot of very recent things that happened, and I know we're running close to being out of time here, so we're just going to briefly go through these things, but a lot of things happened recently. We've already mentioned the fact that at the end of December of 2016, the IRS delayed the rules on opt-out payments that we talked about in the last webinar. Those are the rules that where an employer, offers money to individuals who opt out or waive coverage. That those amounts paid out to individuals could be added to the cost of coverage if it's not done in a certain way according to the IRS. And fortunately for employers, they were delayed indefinitely, and probably not going to happen, but we'll keep watching that. Also in December of 2016, the DOL finalized regulations requiring enhanced disability claims procedures, and so even though insurance carriers typically handle administration for claims, you still may want to reach out to your insurance company and see if they've updated their claims procedures to be in compliance with the new rule. We saw also in December 2016, the district court in D.C. denied the AARP's request to delay the EEOC's wellness rules. In that case, AARP versus EEOC, the AARP had sought a preliminary injunction of the new rules because it found that AARP had alleged that the financial incentives were too high, this 30% maximum under the rules, and they raised concerns that older workers would face discrimination if they didn't provide their private medical information to the plan. And the court ruled that it did not believe that a preliminary injunction was warranted under these circumstances. So that was a setback for the EEOC. There was also a district court that halted the ACA 1557 rules on transgender and pregnancy, and we talked about these in the last presentation. These are the rules that apply to health insurers, TPAs, and other entities that receive funding called federal financial assistance from the Department of Health and Human Services. They had these very comprehensive rules that prohibit discrimination, including discrimination on the basis of sexual orientation and gender identity. And there, we're literally on the eve of becoming effective. The decision was made on December 29th, 2016. And basically the court just said this one was done actually literally on the last day of the year, December 31st of 2016. The court found that these rules about transgender and pregnancy violate religious protections under RFRA, the Religious Freedom Restoration Act. So it halted those and enjoined those rules. Now the other rules you still have to comply with, but with regard to transgender, reassignment and things like that, and pregnancy, you don't have to worry about those parts of the rules. Those have been halted. Now there also was the IRS issued guidance on January 20th about fixed indemnity plans. They issued a memorandum that states that a fixed indemnity health plan that is employer paid or purchased on a pre-tax basis through a cafeteria plan will result in taxable income equal to the amount of any benefits paid under the plan. So that is something that's important clarification. Now, it should be noted, however, by way of contrast, the payments from a fixed indemnity health plan are still tax-free under Code Section 104 to the extent that the premiums are paid by the employee on an after-tax basis. So it is something to note there, but interesting clarification. And finally, the Seventh Circuit recently denied the EEOC relief in the famous case of EEOC versus Flambeau, a wellness decision that we had talked about earlier in earlier webinars. That was the case where the employer had required employees to complete biometric testing prior to being enrolled in the self-insured health plan. In that case, the court just found that the claims for relief were moot because the employer had canceled the wellness plan and the employee had gotten his money back from third parties, so there was no relief that could be granted. So, a setback really for the EEOC in that case, but we'll continue to be watching other challenges to those EEOC rules that come out over time. So with that being said, look, things are changing every day. We talked about the Mnuchin and Tom Price picks getting confirmed. President Trump just selected a new Supreme Court judge, Neil Gorsuch of the 10th Circuit Court of Appeals, who, lots of things are happening every day. So we will keep you updated, and regardless of what happens next in these extremely busy first 100 days of the Trump presidency, we'll keep you updated through web alerts, e-alerts, articles, updates of all kinds, and we'll be watching closely to see just how President Trump fires the ACA. Thank you.
Great information, Dan. Thank you. SHRM, PDC, and HRCI credits can now be downloaded by clicking the yellow document icon to the right of the widget bar at the bottom of your screen. As you exit the webinar, please take a moment to complete the brief questionnaire that appears so we can address any feedback you may have for us. Any further questions can be sent to ashley.whalen@corpsen.com. That's ASHLEE.WHELAN@corpsen.com. Thank you for your attention, and please enjoy the rest of your day.